As noted previously, the stop or detention should be viewed separately from the frisk. However, the analysis is quite similar. Like the detention, the frisk must be supported by reasonable, articulable suspicion that the detainee is armed and presents a danger to the officer and perhaps to the public. However, an automatic frisk is not permitted in every investigative detention. Instead, to conduct a pat-down frisk, there must be at least a reasonable concern for the officer's safety. In Terry v. Ohio, the court explained, "Our evaluation of the proper balance that has to be struck in this type of case leads us to conclude that there must be narrowly drawn authority to permit a reasonable search for weapons for the protection of the police officer. That right exists where the officer has reason to believe that he is dealing with an armed and dangerous individual. And that right exists regardless of whether he has probable cause to arrest the individual for a crime. The officer need not be absolutely certain that the individual is armed. The issue is whether a reasonably prudent man in the circumstances would be warranted in the belief that his safety or that of others was in danger." As the court further explained, in determining whether the officer acted reasonably in the circumstances, due weight must be given not to his inchoate and unparticularized suspicion or hunch, but to the specific reasonable inferences which he is entitled to draw from the facts in light of his experience. The sole justification of the search is the protection of the police officer and others nearby. Therefore, the search must be confined in scope to an intrusion reasonably designed to discover guns, knives, clubs, or other hidden instruments for the assault of the police officer. The Wyoming Supreme Court has agreed with these statements and added details to consider. For example, in Putnam v. State, the Wyoming Supreme Court determined that the officer was not required to take any unnecessary risks in the performance of his duty under these circumstances which confronted him in that case. There, the lateness of the hour, the history of auto burglaries in the area, and the significant factors pointing to the possibility that an auto burglary was in process justified the pat-down. Now, no discussion of Terry frisks would be complete without addressing the question of what officers are supposed to do when they do not find weapons during the frisk, but do find something else, namely some sort of contraband such as drugs. A frisk that reveals such contraband may be sustained under the so-called plain field doctrine, but the nature of the contraband must be readily apparent. In Minnesota v. Dickerson, an officer lawfully stopped an individual and patted him down. When the officer pat-searched the front of the individual, he felt a small lump in the individual's front pocket. The officer examined the lump with his fingers, and it slid and felt to be a lump of crack cocaine in cellophane. The officer then reached into the individual's pocket and retrieved a small plastic bag containing crack cocaine. The U.S. Supreme Court determined that the officer's continued exploration of the individual's pocket, after having concluded that it contained no weapons, was not authorized by Terry or by any other exception to the warrant requirement. The search was unconstitutional. Wyoming has recognized that rule as well as the automatic companion rule. The automatic companion rule allows an officer the right to frisk companions of an arrestee for the possible concealment of weapons.